Hello, and welcome to the Three Questions Podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, if you or someone close to you is a part of a blended family in California, you're far from alone, I'll tell you that much. And you will not want to miss this week's episode of the Three Questions Podcast. What's our topic? Well, it's the three questions blended families should ask when creating an estate plan. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions Podcast, please consider liking this video and subscribing to our podcast and YouTube channels. With over 52% of married couples in the U.S. having a step-kin relationship, and considering California's diverse and dynamic population, so over 40,000 people living in California, the prevalence of blended families here is significant. Today, we're joined by Debbie Babb, a third-generation attorney from Los Angeles who specializes in estate planning for these complex family dynamics. We're going to be exploring the three questions blended families should ask when creating an estate plan. Debbie, welcome. It's great to see you. Thank you for making time for us today.
Oh, it's truly my pleasure. Thank you, Wayne.
Well, before we get to, I'll say this right off the bat, and I remember I said it before we started recording. I've been wanting to do this interview since, we met about a year ago. I think it's been a while now, and I thought, this is somebody I want to have on my podcast. She has a really interesting sort of sub-segment of the population that she caters to, and she's an expert in. So before we get to our questions, why don't we take a couple minutes just to give you a chance to talk a little bit about your law practice, what you do.
Well, I help people who want the peace of mind that comes from knowing that they've taken care of their family when they can't do so for themselves. I serve professionals and business owners who don't want their money wasted on the expense of probate and the cost of conflict that often comes from probate. My firm takes a high touch and a very collaborative approach with our clients, and we craft individual solutions. I really emphasize educating my clients, which allows them, with my counsel, to make decisions which best support their families and their values. I truly have the best job. I get to give my clients peace of mind, minimize the risk that my clients' families will end up in court in conflict, and I get to save my clients' families the expense and stress of probate court. Also, and last but not least, I have the honor of helping families navigate the process involved when a loved one dies. It truly is an honor to be able to serve families during some of their darkest days.
I can't help but think, the term that comes to me is peace of mind.
Yes, I know. I am in the business of peace of mind.
100%. You and I are kindred spirits when it comes to that. And, I want to just go back to that initial conversation we had. And I don't know how it got there, but we ended up talking about the Brady Bunch family dynamic. Now, for those who may not know the history, the Brady Bunch, where this all started was believe it or not, way back in 1966, which I have a 23-year-old who will tell me that's back when dinosaurs were roaming the earth, but be it as it may. So back in 1966, there was a TV producer named Sherwood Schwartz who read a news item in the Los Angeles Times that claimed that 30% of marriages involved children from previous relationships. So back then, that was like kind of a head-exploding concept, right? So when the program was first released in 1969, the Brady Bunch would be the first time that a blended family was ever presented on to television audiences. Up until then, never a chance. So currently, 4 out of every 10 new marriages involves a remarriage, and that really highlights the need for, like my friend Debbie here, a tailored approach to estate planning. I know you probably see it from the same lens as well.
Right, exactly. And I remember watching the show as a
Me
kid.
too.
Yeah, I loved it. But until this moment, I didn't realize that the show was the first time a blended family was featured on TV.
Apparently, that's my in-depth research told me that. So very interesting.
Yeah,
But I
so
remember when that show came out. I was a regular watcher. I didn't look at it, living in Bear River, Nova Scotia. I never thought about from the perspective of estate planning back then, but I definitely get
Right,
it. I definitely get it now.
right. Yeah, exactly. I mean, before, as a kid, it was just pure entertainment. But
Yeah,
now I love the show because I can use it as a fun way to demonstrate the importance of estate planning for blended families. I mean,
absolutely.
what were Carol and Mike going to do with their assets when they passed away? How were they going to split them up? And maybe Mike owned his architectural firm, not sure. What was going to happen with that business? Was he going to leave it to the kids, just his
What
boys?
about Ann B. Davis, the housekeeper? How much is she going to get? Was my question.
Right?
Remember her?
Exactly.
She ran
Yeah.
that. She ran that place like a military operation.
Right. And if Carol and Mike didn't do planning in advance, they'd be stuck with the state's law for them, and Alice would not get anything.
Fascinating concept.
Yeah.
And that's
Yeah.
why we're here. So,
Yeah.
okay. So we're going to be discussing the three questions blended families should ask when creating an estate plan. And our questions are from the perspective of the spouses of the blended family. So question number one to my guest, Debbie Babb. Question number one, how do we split our assets between our joint children and the children from our previous marriage? There you go. We'll start off with an easy one.
Yes. Wayne, I am so sorry to begin our discussion with the classic lawyer answer.
It depends.
It depends. And this is where individual counseling with an estate planning lawyer is really important. There really is no wrong answer. I've had parents equally split assets between all children, even if there's only one joint child. I've had parents leave the bulk of their estate to their joint children because the other children are older and already established and also will be inheriting from the other parent. I've had parents leave twice as much to the joint children than the kids from a prior marriage. Like everything, it just really depends. And we take a lot of time discussing about the best way to handle the split of assets, and it really depends on their individual situation. It depends on the ages of the parents, the ages of the kids, the amount of separate property assets, the amount of community property, and really what's most important here is what the clients feel good about. And
Yeah,
I
and
think,
also there's the compatibility between the siblings too, right? That has to be,
right,
they're
right.
not always Peace, Love, and Bobby Sherman, right? Like, yeah,
Exactly, exactly. Yeah, it really,
another
it
blast from
really
the past.
depends. And structuring the way you leave gifts really makes a big difference in the cohesiveness of the family once the parents are gone.
Yeah, 'cause
So there's a
that's where the
lot.
litigation comes in, right? If they don't do it right up front, the uh the children from the original marriages might get their noses out of joint if they feel they're not getting their fair share compared to the kids from the new marriage, right?
Yes, exactly. There is a lot of cases brought by these children from the prior marriage. It's so many landmines, and so you have to really be very careful about navigating it. And it really depends. And sometimes there's good reason to leave more to a particular child than the other.
Hmm.
And the others, some may not be able to work as well.
Right.
Maybe they have special needs.
Special needs, exactly what I was thinking about. Right.
Yeah, yeah. So I'm sorry, but I gotta leave with it depends.
Well, when I first moved to LA from Toronto, that was the first thing that I encountered when I started making my rounds here in Southern California was I'm notorious for asking a lot of nosy Parker questions, Debbie, and I was a bit dumbfounded by the number of times I would get "it depends" as my response. So I've got used to it. So great answer to the first question. Question number two for Debbie Babb, Los Angeles, California-based estate planning attorney. Question number two. I recently got remarried and my current spouse is 10 years younger than me. Can we create an estate plan strategy to ensure that my children can inherit from me before my spouse dies? Debbie
Ah,
Babb?
This is a great question, especially because I don't have to lead with it
It
depends.
depends.
So, absolutely. However, now I'm going to say it depends. Again, once again, what the strategy looks like is going to depend on the ages and differential in ages of the spouses, the amount of separate property and community property, and the ages of the kids from the prior marriage. We can easily put provisions in the will or trust, which allows for the kids of the deceased spouse, whether from a prior marriage or even the current marriage, to inherit when their biological parent passes. This approach really works best when there are plenty of assets. If there aren't plenty of assets and one spouse is concerned about the other having enough assets to live on, we can include a provision in the trust that the deceased spouse's separate property and their share of the community property goes into a subtrust when they die, and then the surviving spouse can draw from that either interest only or even use the principal if they run out of other resources for their living expenses. But then whatever left over will get distributed on the surviving spouse's death to the kids of the first to die. When we do this, we're making sure there are enough resources for the surviving spouse, but the kids from the older spouse may have to wait a long time for their inheritance. So
Mhm.
where possible, I like to name the older kids as a beneficiary to a life insurance policy or an IRA account. One thing I want to make very clear is I specifically said IRA accounts and not a 401k or similar account. We can do this. We can name the adult children from the prior marriage as beneficiaries on like 401k and other similar accounts, but there's additional hurdles that must be passed. And again, for this type of planning, it's really important to work with an experienced estate planning lawyer. There are so many rules and regulations, and you just don't know what you don't know.
I would also say, yeah, it's also important in this example you gave to have a financial advisor who can also help navigate whether or not it makes sense to roll that 401k over to an IRA at some point, as an example.
Right, right. All yeah, and there's legal involved there too. And I don't want to get into this here. The issue is with ERISA laws. 401ks, you don't want to, the spouse has rights to that 401k. They can be waived, but we have to do it carefully. So if you roll it over, and actually, there's a new law going into effect in California that needs to be navigated as well.
More shall be revealed.
Yes.
Okay, so great. Thank you for answering question number two. Now, I have a follow-up question, but I think I'm going to wait until you answer this one.
Okay.
Question number three. Is it possible to protect our children's inheritance from divorce, creditors, and lawsuits? So
Yes.
take it away.
It's quite possible, and I do this regularly for my clients. When I'm describing it to my clients, I call it a lifetime asset protection trust. That's not something that you're going to Google. You won't find it in the Internal Revenue Code, but it's a way to describe the trust. And basically, when we plan, and by doing planning, we're not relying on the state's plan for us, which is probate. We can direct that upon our death, our children's inheritance should be held in trust for them instead of giving them the money outright or at ages and stages, which is very common.
Yes, I'm very familiar with that myself with my own trust.
Okay, good. Yeah, so you understand. Yes. If we
Yes.
install an independent trustee and give that trustee sole discretion, this keeps the kid's inheritance protected and out of their estate, which protects the inheritance from divorce, creditors, and lawsuits.
It also ensures that, especially for younger inheritors, that they don't receive large sums of money when they're probably not prepared to receive it.
Yep. We have to be really careful about how we leave our gifts to our children. too much money or even a small sum of money at a young age can be a terrible thing for our kids.
Right.
And so, again, you really want to think through this. I don't mean to make this a commercial about the importance of working with an estate
No,
planning
this is why
lawyer.
we're here. No, it's all right. You're
Okay, because it really, as I was preparing and thinking about what I wanted to say in response to these answers, I was like, okay, great, I can share this, but I don't want people to think they can just take this and do their own trust because this is a
no.
very high level, overview. And um,
Estate
but
planning in California is not a do-it-yourself venture. I can say that.
right. I tell people, okay, it's like if you, are working on your house. Paint is fine to DIY, but electrical, you want to find the best electrician you can.
No kidding.
Yeah.
Well
So,
said.
but
Or roofing.
one more thing I want to mention about this lifetime asset protection trust is by keeping, we can talk to our successor trustee ahead of time and tell the successor trustee things that we would like the money to be spent on, what's a good use of the money and what's not. For example, my clients, really all of them, value education. So they're quite happy for their successor trustee to use the inheritance to fund a college education or even advanced degrees. Buying a Ferrari, not so much. So, and we want to be careful about how the money is given to the kids because we don't want to ruin their work ethic, right? So we having these guardrails on is a really good idea. And we often will do this when the kids are young. When people have kids who are in their 40s and 50s and they're in a very stable marriage and they've got a really good head on their shoulders,
They
maybe,
have some experience, basically.
yes, exactly, exactly. So, yeah, again, it's it is possible, and there's a lot to think.
I'll tell you the reason this question it means something to me is the stories. This goes back to my days in Canada, Debbie, when I was working out of my wealth management practice in Toronto. One of the concerns would be around, ownership of property and say a cottage up north of Toronto, which is very famous for their cottage country, the Muskokas, very
Mhm.
well known area. And there would be a family cottage, and the parents would say, "Well, we're going to basically include it for everybody." And then one of the siblings would get married,
Mhm.
and they would get or even live together, common law for say an extended period of time. And when that relationship came to an end, that family cottage would be included in the aggrieved person's claim for as a they were entitled to a part of that property. So that was, you know, protecting yourself when in the terms of a divorce and making sure that the family assets don't get tangled up in that side. And so that trust structure you created perfectly protects that type of a scenario here in Southern California.
Yes,
Although I don't know that sort of thing would happen as often here, but it was something that I was mindful of when I was working with clients up in Canada. So I'm glad the way you structured this and the strategy would seem to cover that if there was ever an opportunity for someone to lay claim to the family assets.
yes, yes. And I know I am not a family law lawyer, but I recently was talking to one and she was explaining that doing a prenup is the same as doing estate planning. We're putting
100%.
a new plan in place for ourselves. We're not using the state's plan for us. So, yeah, prenups are very powerful. I know
And much
people.
easier to do than a post nup.
Yes, exactly, exactly, exactly. And, having an estate plan that's kept up to date over the course of your lifetime and all the assets are in the trust, so much easier than dealing with it at death when if all the I's aren't dotted and T's aren't crossed, it can be very expensive and very stressful and a, a lot more room for conflict, which eats up the estate when there's conflict.
Yes. You just brought something up there. I wanted to just follow up here before we wrap up. How frequently do you recommend that a family, notwithstanding the unexpected events that can occur, but how frequently would you suggest that a family review their estate plan with their attorney? Sort of
I,
on a recurring basis, if you will.
yeah, review with my clients at a minimum of every 3 years. And
Perfect.
yeah, and it can be very simple, maybe not much or anything has really changed at the 3 year mark, the 6 year mark, but maybe at the 9 or 10 year mark. Um, you know, yeah, so at least every 3 years, I think, is the right amount of time. And over time, you're just going to need a whole refresh of your trust
Hmm.
because over time, the boilerplate changes. And, we're so used to boilerplate being meaningless, but in a trust, it's actually very important. Things change over time, and we can put in provisions that either we hadn't thought of before, or the law has changed. So now we're allowed to include these types of provisions. And having a fully up-to-date plan is really important for staying out of conflict. So I recently had a client come to me where his parents had passed away and all of the successor trustees named in the trust had passed away. So this lawyer had never reached out to the couple. And so we had to go, there was one account with a financial institution that wanted an order from the court naming a new trustee. And I understand why the financial institution could have liability. So I get it, but we had to go to court and it took a long time and it was expensive and could have easily been avoided if the plan had been kept up to date.
Current.
So, and then on along those lines is making sure the assets are in the estate and in the trust.
Yes.
So often, what's really a common scenario is where you put your estate planning lawyer, most of them will do the deed, draft the deed for you to sign and get it recorded to get your home into your trust.
Hmm.
But often people will refinance their homes and the lender, I think because they don't understand trust. I don't know why so many lenders insist on this, but they'll make you take the house out of the trust for the refinance and you're allowed to put it right back in, but people
Right.
don't know to do this. And so, if I'm meeting with the client at least every 3 years, then we pull the deed, make sure it's still in the trust and we can catch it. The thing to remember is it's so important to keep your trust up to date because I can't tell you when you're going to die. I don't know what your assets are going to be when you die, and I
Right.
don't know what the law is going to be when you die. So,
I'll
this
give
is
you another example too. On top of that is like for example, RSUs that you end up rolling over. Another example, you end up acquiring shares from your company for some reason. To make sure that your instructions that those shares get put into your trust.
right, exactly. And that's why it's so important for the client's advisors to work together. A strong relationship between the financial advisor and the estate planning lawyer and the CPA and the life insurance agent. Like it all works together. And having people work together and the just in service of the client.
You know, I told you I had another question and I wanted to wait, and I'm glad I did. And you kind of mentioned it earlier about the successor trustee. So this is, you know, personal experience makes it more real. We recently went on a big vacation. We left the continent. Let's just put it that way. So before I left, I sent a note to our successor trustee letting him know that we were leaving, and I connected him with our children to make sure that they knew. I said, we're going to be far, far away, and we were. And I said, you know what? I want to make sure that everybody knows who everybody is, just in case anything happens to me or mom, that everybody knows who everybody is because the successor trustee is going to be responsible for taking care of things if we're not able to. And I want to know if that is something that you've ever, if that is that a common practice, or what are your thoughts on?
I
I got to tell you something. I did it. I was literally waiting while there was a ways away. We got there early to the airport because LAX, right? But we were literally, I was sitting in the waiting area and I thought, you know what? I think I'm going to send my attorney a letter letting him know because we're going a ways. And I sent him a note, I sent my kids a note, and connected the two together. I want to know if you have an opinion on that practice, if that was something you hear people doing or recommend, or what are your thoughts?
I don't. I think it's unusual to do that, but I include that. I think it is so
Well,
important.
you approve is what you're saying.
Oh, yes. And I think what I like to do, especially in the blended family situation where there is more opportunity for conflict, I like when there's adult children, I don't think a 10-year-old should be on this type of
No, no,
call.
no, no. These
But
are adults.
yeah,
These are adult children.
with adult children, I like to offer to my clients and really encourage them. I said, let's set up a Zoom call and you'll be on there, I'll be on there, we'll have all the kids on there. If you want to include your financial advisor or any other advisors, you're welcome to. And I want to share as much of the plan as we decide is appropriate. I won't well, in rare situations, I'll let my clients name co-trustees, but in general, I won't. When you have more than one, you end up with none if they can't agree. And sometimes the couple wants to name one of their children and they are now forced to not choose all three to serve together because I won't let that happen. And so we have to pick an order. And I like to be the bad guy. And I like to make it clear to the others who's not chosen first. I said, this is actually a thankless job. You don't want to do it. And you're not chosen for it because your parents love you any less. And then giving other details so that all the children hear it from the parents all at the same time, I think really helps reduce the chance of conflict. So, and also your children need to know who to turn to if something has happened. And the fact that you let your lawyer know that you were leaving and you let your kids know who the lawyer was. So now the lawyer gets to do one of the things that I mentioned at the beginning, that it's such an honor because they get to help your kids navigate what will happen when you pass away. And it's hard and they're grieving. Like they're already in their worst days. And so already knowing that your parents have put in place a trusted advisor to hold your hand through all this, I think is a huge gift.
Well, you know what? Before we wrap up, and I thank you for that sort of endorsement. I must admit, I was sitting there going, you know what? We're going away for the first time in a while. We travel a lot around North America, but this was our first sort of overseas trip that we'd had in a while. And quite frankly, it was the first one since our kids really became adults, dare I say.
Mhm.
And I thought, you know what, it would be a good idea to connect them with our successor trustee, just so everyone knows who everybody is. So thank you for that endorsement. And I too, back, especially when I was in Canada, um, I used to have those estate planning meetings where I would uh, bring the clients in with their children or their executors and just walk them through what the roles they're going to have. Like,
Yeah.
what is your job? And I would say one thing that has really changed for me personally in my role as an advisor, one area that has, and I've mentioned this on previous podcasts, is, in the past, I'll be the first to admit I would say, you know what, not a bad idea to have your kids as your powers of attorney, seem the most natural, or a
Mhm.
sibling. And, since moving down here to LA, I must tell you, Debbie, and so many horror stories that I have kind of changed my opinion on that entirely. And I would more often or not now recommend getting a third party fiduciary successor trustee to take on that role. Uh, versus having family members taking it on.
Yeah.
That's a personal thing for me. I mean, I'm not endorsing or anybody else on this one, but that's my own personal take based on, quite frankly, how many war stories I've heard and horror stories I've heard from other estate planning attorneys of, especially elder abuse
Wow.
with powers of attorney. So
Yeah.
before we
We're really,
wrap, oh, sorry,
yeah,
go ahead.
we're really blessed in California to have the PFAC, Professional Fiduciary Association of California, where we've got a lot of licensed professional fiduciaries that can
Hmm.
come in and serve the role as the successor trustee or the agent for the financial power of attorney, even the healthcare agent. So,
Yeah,
and
I've taken advantage of that myself, I can tell you.
yeah, good, good.
Before we wrap up, I just want to say one other thing. I've adhered to the principle that, when it comes to wealth management, uh, there is really never the wrong time to do the right thing,
Mm,
right?
yeah.
I just wanted to ask you, do you think does that apply to estate planning? For example, let's say you're working with a couple that's a blended family who, from their perspective, they have just too many loose ends to address in their view, before they can address an estate plan. And then we know what this leads to, right? Procrastination.
Right.
I was just wondering how, when you get that kind of, for lack of a better word, pushback, like how do you address that?
I really try with a joke and I say, okay, well, just don't die before you get your estate planning done. And, you
Yeah.
know,
No skydiving. Nope. Nope.
exactly.
Don't go up to Yosemite.
Right, exactly. So I get it. Our lives are so busy. And when you first marry and say the children are young, you're blending a family together, it's a lot. But if you don't carve out the time and energy to take care of it, you're leaving just a mess for your children.
Right.
And you're making
And
things
estate plans can be updated. We're not writing them on the side of a wall in granite somewhere. They're
a
written essentially in sand to some degree, right? They can be
right.
replaced and
I know we're talking about blended families, but often people, when they divorce, it's actually mostly the women when they divorce, one of the first things they do is their own estate planning. And they will make a plan and then 5 or 6 years at post divorce they're like I want to make some changes, like people have just when they've gotten divorced just come off a really tough time in life, but they know they need to get something in place, and it's good because then they have the peace of mind of knowing that it's done. But then things change, right? They settle into their new lives, maybe there's a new spouse and they know they need to redo things. um on the procrastination piece, I know it's so tough to overcome, but I will say that at their signing ceremony, when they finish signing all of their estate planning documents,
hear the air goes
so
through.
what?
So relieved, right?
Yeah, so but also, well, I do love seeing that peace of mind. I can see it come over
Yes.
at their signing. But then also at the signing, they've just finished signing their documents and they tell me so many of them, they tell me they didn't realize it would be so easy. And I tell people if they'll just take that first step and reach out to my office, we will hold their hand and help them every step of the way. And we do. And they realize, yes, you've helped me, you've counseled me, you've educated me, you've helped me make decisions. And I got this done. And they're so relieved.
For those watching on our website, we've included your contact information on the screen. Now, for those who are listening in on a podcast format, Apple, Spotify, whichever one it could be, could you share what is the best way for them to contact you? I am sure there are people listening today who are going to want to talk to you, Debbie, almost certainly. So, what is the best way for them to contact you?
Well, it would be my honor to help them. And I have a website, DBABB Law, dbabblaw.com. My email is Debbie, Debbie, at dbabblaw.com. And phone is 424-248-0283. And I'm super easy to find on LinkedIn. Instagram, and Facebook.
Debbie, I want to thank you so much for joining me. What a great conversation. I've been looking for it, like I said, for quite a long time, and exceeded my expectations.
Good.
And thank you very much for joining us today.
This was a blast. Thank you. And I'm so glad that we were able to help spread the word about this. People don't know, and thank you for the opportunity.
I look forward to bringing you the Three Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive notification of when our latest episodes have been posted, please click on the notification bell. Lastly, to schedule an online consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we'll see you soon.